This will be a 120 jury charge. Ready? Begin. Ladies and gentlemen, whether the defendant is to be found guilty or not guilty depends upon both the facts and the law. As jurors, you have two duties to perform. One duty is to determine the facts of the case from the evidence received in this trial and not from any other source. Your other duty is to apply the rules of law that I state to you to the facts as you determine them, and in this way to arrive at your verdict. It is the judge's duty to explain to you the rules of law that apply to this case. You must accept and follow the rules of law as I state them to you. As jurors, you must not be influenced by pity for a defendant or by prejudice against him or her. You must not be biased against the defendant because he or she has been arrested for this offense or because he or she has been charged with a crime or because he or she has been brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that the defendant is more likely to be guilty than not guilty. You must not be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the state and the defendant have a right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict regardless of what the consequences of such verdict may be. A defendant in a criminal case is presumed to be innocent until the contrary is proved, and in case of a reasonable doubt whether his or her guilt is satisfactorily shown, he or she is entitled to a verdict of not guilty. This presumption places upon the state the burden of proving him or her guilty beyond a reasonable doubt. The defendant has no burden of proof. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. Circumstantial evidence is evidence that proves a fact from which an inference of the existence of another fact may be drawn. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, in any case based on circumstantial evidence, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the defendant's guilt and the other interpretation to his or her innocence, you must adopt the interpretation which points to the defendant's innocence and reject that interpretation which points to the defendant's guilt. If one interpretation appears reasonable and the other interpretation appears unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Murder is the unlawful killing of a human being with malice aforethought. Malice means either an expressed intent to kill or an intent to commit an act dangerous to human life with knowledge of the danger to and with conscious disregard for human life. Aforethought means the malice must precede the act. First-degree murder occurs when the killing is committed with malice aforethought and a deliberate and premeditated intent to kill. Deliberate means determined after careful thought and weighing of the consequences. Premeditated means considered beforehand. The law does not try to measure in units of time the length of time during which the thought must be pondered before it can ripen into an intent to kill that is truly deliberate and premeditated. The time will vary with different individuals and different circumstances. The true test is not the duration of time, but the extent of the reflection. A cold, calculated decision may be arrived at in a short time, but a mere unconsidered rash impulse will not amount to deliberation and premeditation, even though it includes an intent to kill. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of first-degree murder, he may be found guilty of any lesser offense, such as second-degree murder, voluntary manslaughter, or involuntary manslaughter, if the evidence is sufficient to establish his guilt of such lesser offense beyond a reasonable doubt. Second-degree murder occurs when the killing is with malice aforethought, but without deliberation and premeditation. Voluntary manslaughter is the intentional killing of a human being without malice aforethought. An intentional killing is said to be without malice aforethought and therefore reduced to voluntary manslaughter in the following circumstances. 1. Where the killing is committed during a sudden quarrel or heat of passion, and where the provocation is such that it would naturally arouse such passions, and where the killer acts upon the smart of that heat of passion. The heat of passion that will reduce a murder to manslaughter must be such as naturally would be aroused in the mind of a ordinary, reasonable person in the same circumstances. 2. Where the killing is committed in the honest but unreasonable belief in the need to defend against imminent peril to life or great bodily harm. Involuntary manslaughter is the unlawful killing of a human being without malice aforethought and without an intent to kill. This crime is committed when the killing occurs as a result of an act of gross negligence involving a high risk of death or great bodily harm.